We would like to call the work session to order. Monica Ross Williams is stuck in traffic and she'll be a few minutes late. So I guess we can just go to the agenda review until she gets here. The first item on the agenda is the budget. The only change that I have for which is no dollar change for the budgets, is 14B Court. I talked at length with Mark Nelson, and I didn't budget for that position because it wasn't filled this year. And after talking to him for about an hour and a half today, I got a much better understanding. The position will do collections. So right now, when someone comes before the magistrate and they get a fine, the magistrate or the judge will say, do you have the money to pay that? And they'll say, no, I need to make payments. And so they're like talking this out in front of everyone, and they would hope that this person could help set up those payments so it's not done in the courtroom right now. And they're also going to be overseeing the cash receipts and deposits to make sure that there are no incidences like we've had in the past, and put the controls in. So there's enough money in that current budget to restore that position, because on the indigent fund, which is where people are appointed attorneys because they don't have the money to hire an attorney. So the township pays for the prosecutor, and there's also funding for the defendants who do not have the money to hire an attorney. So it's currently budgeted around $45,000 right now. I have it budgeted at $170,000 because the state of Michigan had not voted to fund the indigent care fund. So if Ypsilanti Township, our court is spending $50,000, that's all we'll be responsible for. And then the additional dollars, if we contract with the county to do, indigent defense, and the contract will come back to the board, by the way, but the grant will go to the county who's actually providing the indigent services. So the budget called for $170,000 approximately, and it's really only $50,000 because the budget that was approved at the state level will pay for the indigent care, which I'm glad. I was afraid they were going to axe that. So other than that, that's the only changes from all the meetings. If it's okay with the board to make those line item changes, I'd like to do that. It doesn't affect the resolution. It doesn't affect anything that's currently in the budget.
All right. I'm fine with that.
Okay.
Okay with me.
All right. I spoke with Karen. Yep. So, are there any questions on the fiscal budget? None. I know we went over it. Yes, Miss. Is it on, Miss Kaiser? There's a little light that should be coming in.
Oh, it's okay. My name is Arloa Kaiser, live at 1421 Melvin Street, and when I looked at the budget, it appeared to me, if I can count, that there are approximately 17 new positions and old positions that were not filled. Is that correct? Approximately?
17?
That's what I counted.
No.
So, okay.
No.
But it seemed like there were quite a few positions that have been filled and new hires. So from that, I figured that we are doing pretty good financially. And to me, it seemed a little scary just all of a sudden to have that many.
Yeah, so the Restoring Human Resources Assistant was one. The residential services director position, Jeff Allen, is still vacant.
Okay.
So that was in the presentation. And we had a parks operations superintendent, and we wanted to restore that. And we have a building operations superintendent. We had two positions. We merged them together in 2008 and 9 in order to save costs. So we want to go back to where they will be over each department. So we're adding one. And then there's the financial coordinator position that was already budgeted in 18 for 14B Court. We have a vacant chief building official, but that's just vacant. And we have a full-time hydro operator that is new. In 18, we added the equipment operator to the compost site, a custodian to law enforcement site fund. We have a compost facility manager. He was already doing one of the jobs, and we moved him up to the compost facility manager and added the heavy equipment operator there. And deputy of elections was added in 18, but that was just from an existing position, and it was moved
Just
up with
increased wages.
$2 more per hour. And then the same was true for the assessing department. That was an existing position, and they moved it into management with additional funds. And in 18, we also added a assistant director of golf operations, but that was in 18.
Okay, it just seemed like a lot all of a sudden.
No, you're right.
We haven't had
Yeah,
many
it's quite a-
increases.
It's 7 positions, 3 in 18 and 4 projected for 19.
Yeah, it is. Ms. Kaiser, it's been a long time since we started filling positions, I agree. But
I'm not complaining, but we must be doing awfully well to have enough money to do this. I'm just curious. In the past, we've been really,
yeah, and I think that we had a lot of people doing a lot more jobs. And to have someone over the parks, like, I think that'll make a good,
but I do appreciate what the board has done to cut costs. Just all of a sudden, it's.
and a back in. And it's within the existing budget. Nothing's coming from fund balance so that's good from an operations standpoint. But that was a good question. Thank you. And we did have a 7.4% increase in taxable revenue. So that's all the new houses, the new additions that people are putting, the businesses. So that helped, of course, in order to restore the positions, too.
Thank you.
You're welcome. Are there any other, I know we've talked about this budget for, Stan, do you have any?
I'm good with the budget. The only thing is kind of to follow up with Ms. Kaiser, is we are doing better. I just want to make sure we're cautious because I still, having been here through the last downturn, worry about another one coming soon. So I just want to make sure we're prudent with everything that we do and that it's absolutely vital or necessary if we add positions or spend money anywhere, actually. That's it.
Concurred.
I just wanted to say thanks to Giovanna and Tammy and Brenda. I know it's a big job to put the budget together, and you guys have been so helpful in the line items. It's like a layperson can just pick it up and really understand, I think, what we're doing in the township, and I think transparency is great. So great job, guys. Gals, great job, gals.
Thank you. Thank you. All right. So we'll vote on the resolution tonight, if that's all right with the board. Unless a lot of public comes in, I don't think there's any issues with that. The minutes of the work session and regular meeting, that was distributed. Any questions or comment?
Thanks for your patience on the work session minutes in particular. As you can see, they're extremely long, and we have a new person that was doing them, and with all the injuries and illnesses and some scheduled time off in our office, we finally got them done today, so I appreciate you having your patience.
And we did have an issue with
Oh, yeah. And with the recorder, the regular meeting doesn't have a lot of stuff other than the motions. Thank goodness we wrote those down. I have no idea what happened, but for some reason, we didn't get a recording of the regular meeting. But the detail is really in the work session, which we did have, thank goodness. So apologize for that.
All right. Monica, you're here, so we want to start on your agenda item, which is the discussion of stipends for Park Commission, Planning Commission, and ZBA. We did have a resignation, another resignation, of the Park Commission Chair. He is moving to Saline, so we'll have another vacancy.
I said, we'll need to appoint that, otherwise there'll be an election.
Right, within 45 days.
Was it 45 days we have?
45, right?
Yeah, I do know that. Yeah. We learned that. But they have to notify us, Karen, and
Oh, he hasn't officially
he
done
has,
it.
right, he has to officially notify the clerk of the resignation, so,
So we have 45 days after the point that he notifies us.
correct.
Thank you.
Wow, okay, hi. And excuse my tardiness, I've started a new job, so I just want to make sure people in the audience know. I wanted to bring up for this point for discussion, and it's basically the stipends for the planning, zoning, and also Ypsilanti Township Park Commission. So just a little bit of background, some of this was already inside of the memo that was written. Ypsilanti Township has three boards, a little bit more than that, but that receives monetary stipends anyway, is three. Those boards are the Ypsilanti Township Park Commission, that's comprised of 7 elected commissioners consisting of the chair, vice chair, secretary, treasurers, and 3 commissioners. The Park Commission, as most folks know, is an elected body chosen by the constituents every 4 years with a term ending in November 2020. They meet once a month unless a special meeting is scheduled, and the commission develops policy and has inputs on capital outlay as it relates to parks and represents resident matters as it relates to the township parks. The Planning Commission is comprised of 7 appointed commissioners consisting of a chair, vice chair, and secretary, and 4 commissioners meeting twice per month. And the commissioners are approved by the township supervisor and the board of trustees. The Planning Commission currently makes recommendations to zoning plans, district ordinances per the township allowance, approve special land uses and plan development and site plans. Last is the Ypsilanti Township Zoning Board of Appeals that consists of 5 members, including the chair and 1 alternate. The ZBA, which is a short term for the Zoning Board of Appeals, is appointed by Township Supervisor, approved by the Township Board of Trustees. The ZBA is a quasi-judicial body with the authority to hear and determine appeals of administrative decisions, variance applications, and to make interpretation of zoning ordinance provisions. So, in the line of doing some research in regards to this item, I wanted to know basically which of the boards within designated time period have had any other stipends increase. The Parks Commission, this is from our Human Resources Director, Karen Wadding, has been at $50 a meeting for years. But the Planning and Zoning Board of Appeals, they went from $40 to $50 per meeting in February of 2018. So that's a little bit of the history there. So next thing that I looked at is basically the budgetary line items as it pertain to each of these commissions. Basically for parks, the salaries, that's elected officials. It had a amended budget of 6, and this was as of 10/31/2018, so this number could have changed since then. But as of 10/31/2018, it had an amended budget of $63,000, year-to-date balance of $3,350, and an accumulated balance of $2,950. And it was only 53.17% of the budget used. For the Planning Commission, basically had the same amount of amended budget, $63,000, and the balance as of 10/31/2018 was $3,582. Accumulated balance is $2,718, and they have used 56.86 of the budget, of their budget. The Zoning Board of Appeals, ZBA, as stipend on the budgetary items is, they had amended budget of $3,000, a year-to-date balance as of 10/31/2018 of $1,100, an accumulated balance of $1,900, and they used 36.67% of the budget used. Okay, so moving on. So one of the things I wanted to look at also was how does Ypsilanti Township ranks, at least population-wise, to some of the other communities that will be talked about as we look into how their stipends work. So Canton, this is basically comparison information from SIMCOG 2017 reporting, so last year. SIMCOG is the Southeastern Council of Governments. In Canton Township, basically, their population was 93,791. Ypsilanti Township's 56,888. Pittsfield Township, 39,370. Van Buren, 29,585. And Superior Township, 23,324. As it relates to Parks Commission stipends in some of these communities, they have a leisure committee, so they don't have a park commission. Pittsfield, they get paid $100 a meeting. Superior is $86.49, and Van Buren does not have a park commission. The median per stipend, if you divide it by two, is with only two that actually have a stipend, is $143.25. But if you divide it by four, it's $121.62. So, zoning boards in Canton is $60. Pittsfield $100. Superior is $80 a meeting plus $100 for the chairperson. Van Buren is $25 a meeting plus $30 for the chairperson. And if you do that with the stipend, that basically it comes out to divided by four for the commissioners themselves is $66.25, and then if you do it for the chairperson only, it's $115 because that's only divided by two. And last but not least, the Planning Commission in Canton is $80, Pittsfield $200, Superior is $80 per meeting, but $100 for the chairperson. And then Van Buren is $25, and this is stipend on that one for the commissioners only would be $96.25. Obviously, for the chairperson, you only have one that actually gets a stipend out of these communities, so it would be $100. So I guess my questions are consisting of the following, which I would, want to bring to the board for discussion, is I guess, I'm going to start with the Park Commission and then move on to the other ones, because the Park Commission, according to the information that was given by Karen Wally, has been set at $50 a meeting for years. The Planning and Zoning Commission did go up from 40 to 50.
Well,
Yeah.
If I could just, I think the Planning Commission and the ZBA went from 50 to 40
Oh, it went from 50 to 40.
during the hard time.
Okay.
And then we raised them back up, but we can verify that, but
Okay.
I'm 99% sure that's what happened.
Okay, all right.
So they were, is that correct, Stan? It was decreased during that period?
I think so, but as you know, I've never taken the stipend,
Yeah.
so
Yeah.
I
I
think,
think that's what it was.
I mean, that explains.
Okay. Thank you, that does help. So, and going back to both of those, actually, if we look at it as comparison to other communities, except if we count Van Buren, at least when it comes to the Park Commission, between Pittsfield and Superior, $50 a meeting, there Pittsfield's at 100, Superior's at 86.49. I don't believe that, obviously, the median is going to be way high on this one because of the fact that we don't have it to be able to be divided by four, only by two. But in the same aspect, I guess my question would be, is anything warranted, even if it's $10 additional per meeting? And should it even be a difference between the chairperson and the rest of the commission? That would be my question there. That would be a similar question with the zoning board, ZBA, because two of the communities do have a designated amount for the chairperson. And with the planning board also, if none of the stipends would be in consideration for any review, I would definitely say that we, my opinion anyway, is that we should look at some type of stipend review for the chairperson at the very least.
Okay,
Madam Chair,
yes.
Monica, I was wondering if you could walk me through under the Park Commission stipends, the math at the bottom there.
Yeah, so basically, so it's kind of like, the median gets off because of the fact that we're looking at, you divided by 2, right? And then divided by 4.
So you're adding
yeah.
Pittsfield and Superior.
Yeah, exactly, right, yeah. So you don't have the other 2 to compare,
Right.
which makes the median go really high, which I don't agree that it should, that should be an amount that's used for an average, but.
Well, I was just,
Yeah.
I just quickly was doing that, and the average, if I divided by 2, just adding those together, was like 93.25. So I didn't know if I'm doing, we're not doing the same math, so I didn't know what
Yeah.
I'm not doing right. And then if I divided by 4, it was 46. And again, I know you're not talking about specific numbers, I just wanted to know, your,
Yeah.
Process.
So basically, I added it and then divided it. So
Okay.
maybe it was a difference.
yeah.
One thing,
Yeah.
I was just going to say, I think on the,
It's on, it's on.
it's not, I think on the Park Commission, if Pittsfield is 100 and Superior is 86.49, that would be 186.49 divided by 2, not 143. That's probably where she has it off, which would make it more like a $90, 90-some dollars would be the average for the median. I think there was just a mathematical, median stipend per meeting.
Yeah.
It's not 143, it would be the 186.49 divided by 2.
Okay, that's fine, I asked that.
Yeah, so it just, I think that's probably why Heather had it differently. So it would be like around $90 a meeting.
Which is still way more than we.
Yeah, it's a little high, to say the very least.
Madam Chair?
Yes.
I guess I just have a quick question. When this first got broached, I certainly had no problem with it. I still don't per se, but my question would be on the Park Commission, why Van Buren doesn't have one, because they seem to have a fairly robust park system in their community, and what the difference is between a Park Commission and a Leisure Services Committee. And the last I recall, unless something's changed, our Park Commission doesn't have a budget really to work with on their own. And so, that just opens up other questions as to increasing a stipend for a group that doesn't necessarily have a budget to work with. And what's the difference between having no commission versus a Leisure Services Committee and a Park Commission? What is the differences between all 3 of those, and where would we be best served moving forward?
All right, you're not asking me that question.
No, just a general.
Okay.
I don't, that's the first time I've ever heard of a Leisure Services Committee.
Right, yeah, no.
I wasn't aware that Van Buren didn't have a Park Commission.
Is this for 2020?
According to Crystal Review, pulled some of this information for me, but in the same aspect.
No, I mean, because the budget we're voting on
Right,
tonight.
yeah, it wouldn't be for 2019.
Okay, I just-
But, 2019 budget is done, so, yeah.
If I may,
Yeah,
just to speak to Trustee Eldridge's question, park commissions are actually governed by statute and legislation. It's very specific, whether you're charter or non-charter township. So I'm guessing they don't have the legal Canton. They probably just did a Leisure Services, maybe to have public input, but it wouldn't be, it's not a legal body as governed under statute. That's the only information I would have.
Madam Chair. Yeah, I don't know why, I could always go back and ask. I'm not sure why Canton has a Leisure Service Committee comparison to a Park Commission, but I can definitely find out that information. As it relates to the Park Commission that Ypsilanti Township does have, though, we do, and I don't know, and this will be a great comparison question, which I can actually go back and do research on. I'm not sure how many parks Canton have. But I know Ypsilanti Township has 27. So yeah, that is a lot of park space between the mini parks, the community parks, and the neighborhood parks. And then I do understand your point about the Park Commission doesn't have a budget to manage, which is true. But they do manage basically policy, creating policy as it relates to how much it costs to even get into a park. I know that was a question that you had raised not too long ago. And then also basically equipment recommendations that they bring before the township board as it relates to different equipment or maintenance issues that need to be evaluated for the board to review for budgetary matters. So there are maybe, and I say this because I actually, was a park commissioner. I think that there's a lot of things that the Park Commission does that, is very valuable to the township, even though they don't have budgetary responsibilities. So that's my comment on that.
Madam Chair,
Yes.
through you to Trustee Eldridge, I would have no problem with making the, in the future, thinking about having our Park Commission be an appointed board instead of an elected board. Then we can appoint, over the years, we've seen certain commissioners where they use it as a political forum instead of we need people who really are there to serve what it's for. And I would have no issue with making it appointed instead of elected board myself. Comparison to the other communities, I would have no issue with raising the stipend. Because like Trustee Ross Williams said, it still has a purpose. And if the stipend has been such, $50 for a long time, I wouldn't have no issue with increasing it slightly. I don't know if she had a certain number, target dollar that she was looking at, but.
I think that, which I appreciate her saying that it's not for 2019.
Right.
So you would probably do more research and maybe have a small committee, maybe look at, or I'm willing to look at it. I agree with Trustee Wilson. We have had a hard time with getting park commissioners to run for office. We had an issue with someone who resigned, which caused another election. So my understanding of the history of it, and maybe that would be important, is the reason why we have a park commission is because we had the golf course, and they had to oversee the federal funds that transpired with that. It was required for us to have a park commission. So at one time, we increased it to 9, I think.
Yeah, it was.
And then we decreased it to 7, and we're still having trouble keeping, people running for office. And maybe if it was appointed, then it would be more engaging to do that. I think we have to have a vote of people to do that, but the purpose was solely for the Green Oaks Golf Course at the time. That's why there's no budget attached to the Park Commission.
Can we just include in that research how Van Buren, which is a charter township as well, how they are managing their park system and open land without a park commission, just so we can do the due diligence? Mm-hmm. Because as some of the board member knows, we've had other people come to this meeting and ask why we have that board sometimes, or that commission, because
Right.
we're always seeking a full commission. We seem to
Right.
always be running behind.
Right. I don't think they're required by statute to have them. For us, we had to have it because of the golf course. But not every, like Augusta Township, or not every community needs to have an elected one. I do think it's a good idea to have, a commission. I appreciate what they do, and
Madam Chair, I would concur. It's not, even in the statute, it does not have to be, excuse me, sorry, I'm getting over a cold. It is a choice of the township whether they have a parks commission. In the same aspect, to concur with Trustee Wilson's comment, is that, and also Supervisor Stumbo, I can understand that, yes, it has been some issues in regards to keeping that board a full body. And that is, disturbing, because it does serve an important role. I mean, there's one park commissioner that has been there, I think, going on close to 16 years, at least if nothing else, 14. And so, looking at, if it does have to be a vote of the people, looking at if that particular body should be appointed versus elected, would not necessarily have an issue with that. But I do believe that, to get back to Trustee Wilson's question, and we're talking about 2020, so we're not talking 2019, that the, stipends should be reviewed and looked at and increased, honestly. And if you're going into an appointed board, that might even make it better, because all the other boards are appointed. The Zoning Board of Appeals is appointed, the Planning Commission is appointed. So those would just be my comments on that. And I have no problems with doing the research in regards to why Van Buren doesn't have a park commission, how many parks they have, comparison, Pittsfield, Superior, and why they have a leisure services commission, and how many parks they have. So I have no problems taking on that task at all.
And if the board wants to study it more and bring a recommendation back for the park commission, for the commissions, we can do that at a later meeting, but it would just require a budget amendment. I just didn't want to mess up the budget that was presented.
Madam Chair, I just offer, Monica, I'm interested in stuff like that, so if you want help doing research, we can like split them up and, or whatever.
Thank you.
Madam Chair, I just want to make one more comment. Looking at the other communities that were listed here, and I look at the Planning Commission, and that's a very important, they're all important, but you look at the Planning Commission, and they hold a lot of decisions that, affect, businesses coming in, practically. And I'm looking at the other communities, and I wouldn't have an issue with our Planning Commission, doubling their stipend from 50 to 100, because it's so important. I think the zoning board is probably about accurate, especially since we only meet maybe half the year when there's applicants.
Well, the ZBA can only be appealed to circuit court, though. So it's a very important.
Right.
Well, it's required too by statute. But.
Yeah, like I said, they're all important. I look at the Planning Commission, and I'm looking at the other communities that a lot of development going on, and
Well, we can bring back a recommendation.
Yeah.
Once you get a little bit more information, maybe a few other communities.
I have no problems with, and Trustee Rose said she would help. So I have no problems bringing that back to the board after a little bit more investigation and trying to.
So you're just looking for direction.
Yeah, and basically at this point, and then make sure that Trustee Eldred's questions are answered in regards to some of the communities. And thank you for bringing up the Planning Commission, Trustee Wilson. Appreciate that point. Thank you.
I think it's a shame that Van Buren's only paying their people $25 a meeting, though. I think that all their boards, $25, that's pretty ridiculous. So I guess we are, at least, we have some sense over here. That's all.
Okay. All right.
Thank you for bringing that forward, Monica.
All right. Ms. Kaiser? Ma'am? I think it's on.
It was mine. I brought it before the board.
My question is, what has happened to the idea of community service from the citizens of the township? And I agree with Trustee Wilson about having an appointed board. Everybody wants more money, 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 money. So what happens if we have a downturn? Look at GM, they're talking about closing plants. Is this a vision that we should be paying attention to now? Yeah, I'd like a raise at my job too. Everybody wants a raise, but this is community, and don't you have to think of community, the people that live here? and do the best for them, and money isn't everything.
Thank you,
And
Ms. Kay.
appointment, I think, is a good idea, because those are people that are eager to have that position. And to me, yes, being voted on, they want a job to move up higher into the higher realms of the community election system and blah, blah, blah. I am opposed to it as long as if they're happy with what they have, they're doing a service to this community. And I'm opposed to just keep raising all these different salaries here and there, hiring just a bunch of people because it might help us a little bit more, not necessarily financially, but consider taxes and the common people that don't have the money and the older people that are living in the community. And I think it's more older people who have built this community than the young people that are moving in.
Thank you, Ms. Kaiser. All right. So we'll go back to the, is that it, Ms. Monica? Yeah. Okay.
All set, thank you.
All right. The, under old business, we do have the second reading of the proposed ordinance. Charlotte asked me if she should be here, and I said, no, just come to the 7 o'clock meeting. That's when the petitioner will be here. But Mr. Winters, I know you've been working on this with Carlisle Wortman, Dick Carlisle. I know that Mike Radzik has also, they addressed a lot of the questions that were asked in the previous meeting, and there is an actual agreement in the packet now. There's a proposed ordinance that they're working for that will, first reading will be at the Planning Commission in January, and that's our target date, and then it'll come to the Township Board to make sure we have this in the process for the future. Mr. Winters, is there anything you would like to add?
I was trying to get connected over here. I don't know exactly as to what Travis has done to my computer. I think he's got me blocked here. You guys connected?
So is that your comment, sir?
That's the first comment. Yeah, you guys connected?
Yeah.
Okay. Mike, you want to go ahead and then I can fill in whatever you got.
Let's see if it's an operator. Are there any questions from the board on this? Has everyone read the packet?
I just wanted to say before Mike gets up, and I appreciate working with Mike Radzik, and I know that is a really long agenda item, but I think it's such a legal thing that we're voting on that I wanted in the future that anybody can look this up and know exactly if we vote to approve that tonight and included the agreement on the conditional stuff. And I really respect the work that you guys, both Doug and yourself and Charlotte, whoever else worked on this, to put that together in a manner that I'm totally comfortable with it. So, but I apologize for the length of it, but that's the reason why. So this is very legal, so anyone can look this up and know what happened to this piece of property down the road, either by the address or by the parcel number. Thanks for your work, Mike.
You're welcome. We all wanted to make sure that we had a complete and thorough record from beginning to end of what happened with this rezoning request. So I'll just highlight briefly, unless Doug can get up and running there, the changes since the first reading. You'll recall the first reading was approved strictly as a rezoning with the prohibited automotive uses and a deed restriction that would reflect the prohibition of those automotive uses. Following first reading, there
They were already up here, and I don't know who had the last meeting that didn't plug them in, because they were in here when I came in here today. So I forgot to take them out and charge them up.
get up close here now.
Yeah, last night, wasn't it? Yeah, so, sorry about that.
So after the first reading, we had got some very specific direction from the board. Brenda, Doug, and Dick Carlisle had a meeting, and they reviewed the state statute. And we wanted to ensure that we were meeting both the spirit and legal requirements and intent of the state law. Carla Wortman Associates also then drafted at our request a proposed ordinance that would be brought to the Planning Commission and then the Township Board, and then added to our zoning code with a complete beginning-to-end process on how conditional rezonings would be handled in Ypsilanti Township. So what's before you tonight is in substantial alignment with what that ordinance will say. The primary change, rather than having a deed restriction, there's going to be a conditional zoning agreement that was drafted collaboratively by all of us. Mr. Winters has reviewed it and approved it. And the specific list of prohibited automotive uses are outlined in that legal document, that contract. And the rezoning, if approved tonight by the board, would not become effective until that zoning agreement was fully executed, recorded with the Washtenaw County Register of Deeds, and a certified copy of the recording document provided to the clerk's office for the official record. That way, years in the future, anybody that looked at that property would see it and would know that it's there and it runs with the land. The other change is that we had some very open and friendly discussions with the applicant who made this offer to rezone it this way. And they were concerned that they wanted to make sure that the coast would be clear through the regular planning approval process to build their tennis facility. And so if you look at the actual contract, the rezoning agreement, in the first page recitals, paragraph B, it specifically says the purpose of the rezoning is to develop the property for the primary purpose of creating an indoor and outdoor tennis training and recreation facility. And in addition, they propose to develop some outlots, commercial outlots along Michigan Avenue within that B3 zoning with the prohibited uses. The uses are specifically listed in paragraph C, and also in paragraph C, it states that phase one, which would be the tennis facility, the northern portion of the property would be restricted just to that use, and the southern portion would be restricted to the B3 uses, including retail shops, offices, and restaurants. I'd also draw your attention in the actual contract, paragraph 5.2, which is entitled Expiration. This essentially says that the conditional rezoning is subject to the developer getting final site plan approval and commencing construction of phase one, the tennis facility, within 2 years of the effective date of the rezoning. Once that's complete, and then they move on to phase two, which is the outlot commercial development, then they're free to do that, but there is no time constraints on phase two. But this gives assurance to the township that they will move forward as they intended with phase one, the tennis facility. It must be done within 2 years. And if for any reason the agreement expires by its own terms, in other words, they don't meet that requirement, it says they can either come back and petition the board for an extension. The board has sole discretion to determine whether or not an extension is warranted based on the facts and circumstances at that time. And if it does expire on its own terms, the township board has sole authority to rezone the property following our procedures in the zoning code. So we all collaboratively felt that this meets the spirit and intent of the state law. The conditional zoning ordinance that will be coming to you in the next month or so is in alignment with the way this is being done, and we feel that there's adequate protections both for the township and for the developer to move this forward.
Madam Chair,
Yes.
I just had one question. I'm trying to go back to the section it was in. But under one of the sections, it says that the applicant agreed to not have passenger bus stations on the property. And so I just wonder how that looks later, because later in the agreement, it says if any part of this is altered or changed, then the contractor agreement would be like voided, because we wouldn't be upholding our piece of it either. But I mean, do you guys ever foresee that being a problem? Like if the bus routes expanded out that way or anything like that? Sorry, Mike. I know that.
I think any
That would just be
changes would have to be upon mutual
Okay.
consent and agreement of the developer, the planning commission, and the township board if the board is involved in that process at that point.
Okay. Probably unlikely, but just thought I'd ask. Thank you.
One question, Madam Chair. And it's great to hear that this might go forth for indoor-outdoor tennis training and recreation facility. That'd be great. If for some reason the developer does not go forth with the phase one of the planning in 2 years, does it still stay zoned with the, make sure I have it correct, as a general business, would still stay zoned in that area unless for some reason it came back before the board in order to put it back to multifamily residential?
If it expires on its own terms,
Right.
meaning the scenario you just described, the township board has the authority to act
Okay.
on its own to either leave it the same, revert it back to what it was, multifamily, or rezone it in any other way that would be permitted under our zoning code.
Okay, that's all I wanted to know. Thank you.
Doug, did I get that?
I'd probably clarify that by saying that at the last board meeting, what the board approved at first reading was simply kind of a rezoning to B3 from RM2 minus those automotive uses. There was no bookends as to the alpha and omega in terms of the time period, nor was there any kind of sunset provision in regards to that, et cetera. The conditional rezoning movement kind of came out of a number of years ago when people would come to a township board, planning commission, and say, I want to rezone it to B3. And the planning commissioners would say, well, we don't want this or we don't want that, because if we rezone it to a B3, there's some things we like about the uses that we could accept, others that we don't. And of course, when you do a straight rezoning, you don't get a chance, you don't get an opportunity to say yes to 4 or 5, no to 7 or 8. You either vote it up or vote it down. The conditional rezoning was deemed to be kind of a compromise where the parties would put their cards on the table, more or less, and say, this is what we plan to do, this is what we want to do, and here's what we're asking, or why the board to approve. In this case, the property may be master plan, I understand, for B3. Right now it's zoned RM2. And so the agreement that Mike is talking about that we worked through specifies that phase one is supposed to be the indoor-outdoor tennis facility. Last time they were here, there was no commitment to do that beyond just saying this is what we want to do, but there was no real bookends as to when it was going to begin, what the timeline was going to be in writing beyond just what it was. This requires it to be done within 2 years, unless, as Mike indicated, there has been a good reason as to why it needs to be extended. They're 75% done. Something happened along the way. More likely than not, the board would say, yes, we'll extend it for another year. Don't know what the board would do, but you have that option to do that. The uses that have been identified as being prohibited, are part of this agreement. Back to Trustee Monica Williams' question, if this actually became a void document, in the past, it's supposed to revert back to the zoning from which it came, which means that it go back to the RM2. Myself, I think, and Dick Carlisle, Mike and Ben, we all talked this out. It'd be our preference that actually happen, even though it's not required by statute. We would probably do a rezoning by the board that it would go back from this B3 back to RM2, or to something that would be more appropriate depending upon the circumstances at the time. But normally speaking, if a conditional rezoning does not go forward, for the purpose identified herein, and normally if you don't grant the extension for whatever reason, normally no harm, no foul. The intent is for the parties to go back to the position they were in prior to the conditional rezoning agreement. And this was our first one that the board has dealt with. Dick's dealt with quite a few of them. I've dealt with some in other areas over the years. But But I think in this case right now, it makes a lot of sense because the 2 years gives them the primary purpose was to go forward with the indoor-outdoor tennis facility, and the B3 minus these uses will probably develop according to how the economy continues to either go up, sideways, or status quo. So I do think you have, at least in writing, something that's going to be binding, recordable, and because even on the last time, the declaration or the covenant prohibiting those automotive uses, that covenant would go away if the conditional zoning, if the conditional rezoning failed. In other words, if someone walked away and said, it didn't work out, you could not keep in your, you can't just keep what they had originally agreed not to do if for some reason the conditional rezoning went away. But all that aside, we worked it through, I think, in a way that's in keeping with what the board wanted to see achieved. As Mike indicated, it'll go to the Planning Commission, they'll do their reviews, and hopefully in 2 years, everybody will be able to play tennis or pickleball.
And there's one other very important distinction to remember with conditional rezonings. It's that the developer, the applicant, is voluntarily, of their own volition, making this offer to the board. In other words, they're saying, we're offering to rezone this to this and this for this primary use with these time limits. And then if the board chooses, you simply accept their offer by approving this or reject it by denying it.
All right. Any other questions or comments on that? This was a good one to learn on. Thank you. If it's all right with the board, could we move forward to the request for the FOIA so we can discuss that in work session? All right. So we have a request to appeal the Ypsilanti Township Freedom of Information estimated processing fee. The information is in the packet, and the process is, in order to appeal that cost, they have to come to the township board. That's the process, which is why it's before us, because that is the process.
Yeah, they had to submit in writing the specific reasons for the appeal, which you have in your packets.
All right. Yeah, that one's not working, I don't think. Is it working now?
Oh, okay. I just wasn't sure if it was the right time to come up yet, or.
So all the information was in the packet?
Okay. Yes, Myla Harris. I am the ASME Local 3451 Vice President, also a township employee, 25 years. So, yes, the packet, the information that I submitted, Madam Supervisor, was put back to completion. So before I even begin, I just hope with me coming forward, there's no retaliation, harassment. I'm not here to ruffle any feathers or anything. I'm just doing what I was instructed to do as far as to appeal the FOIA with the direction from the clerk's office. So that's why I'm here today. So just submitting the packet, I just really wanted to kind of ask the board, what is the proper procedure? Because to my knowledge and from other grievances that I have filed with other elected officials, just coming to present the information just seemed to be very interesting that it has prompted this huge outburst for some reason. So let's just say that I was the Washington County Road Commission and I submitted some information for my agenda to be placed on the agenda, to be placed as part of the board, on the next board, and the packet and the information that supported it. And that's all I was doing. So it was just very interesting to me that it prompted responses. Because, like I said, if I'm Washington Road Commission, once they submit something, right, that's what it is. It's not where, to me, the trustee's responsibility to direct any direction on what should or should not be said or should not be submitted, especially if the trustees aren't in that capacity to make those instructions or directions. So that's just where I was on the whole thing. Wasn't expecting any comments, wasn't expecting anything. I submitted my information. So that's just where I am on the submitting of the FOIA. Wasn't expecting this type of response. So yes, of course, when I submitted my paperwork, as instructed by the clerk's office, following directions with the revised from Clerk Rowe, then that's when I realized my packet had been edited, I guess is the correct word, last 2 pages, which speaks of the grievance for the FOIA, the settlement for the grievance that was stated that Clerk Rowe did was in violation of the union contract. So again, if I'm Washington County Road Commission, for example, is that the proper procedure to eliminate, edit anything that someone wants to be put on someone's paperwork or backup paperwork to be submitted with their agenda item? So I wasn't expecting that also. The only reason why, another question is it protocol or common that I wasn't even notified that my packet was even edited at all? So let me tell you how I found out about that. I did my own research.
Let me find out what the
Okay.
thing people submit.
So let's just say if I was Washington, let's just use an example.
Yeah.
So if I was
Process.
Washington County Road Commission and they sent and I sent, as we're playing this hypothetical, and I sent in the paperwork via email through the clerk's office, is it protocol for any kind of discussion before the board meeting or work session at all from any trustees, the clerk, the deputy clerk? Is that common?
Are you asking me
Yes,
about putting together the agenda?
So the responses that I got.
Can you just tell me, are
Okay.
you asking me a question
I'm
or not?
asking you, yes,
The
I'm
process.
asking you
She's
the
just asking
process.
the
Yeah.
That's it.
The process is the stuff comes in between Lisa and I, we review everything. You can ask every department head, they get really frustrated with me because I say it's not in proper form, I send it back to them, or I'll take stuff out, or ask them to submit more stuff. So yeah, that is kind of what I do, but that's really not the purpose today, it's about the appeal.
I know, but
It has
the
nothing to do with the
FOIA,
appeal.
Or just,
right, so I just needed to know what the proper
Yes.
protocol was because.
Yeah, I do put together the agendas and I add
And so
stuff.
is that person normally notified if something's going to be eliminated? Because you did say, like, if it's not the correct format or whatever, this had nothing to do with format. It was just, I sent it, and no one said anything to me about that at all.
the good news, it was added back in.
So, yeah, I
Yes.
did. So then, but if I hadn't noticed, you see what I'm saying? That's what I think that needs to be addressed. If I hadn't noticed that it was not put in, that it would have just gone as my last 2 pages were eliminated. So
Okay.
that's one of my problems. So the grievance prompted the FOIA request. So during the steps of the grievance, we had a discussion, and Clerk Rowe indicated that this was a one-time incident. And I know that as far as violating, bringing in her daughter to perform ASME responsibilities. And the reason why the FOIA was prompted before the hearing is because I know that that statement was not true. So in order to support my grievance even further, that's where I decided to request the FOIA. So then I never got it for the hearing. I think the hearing was October 25th. So I did ask, can I get the status? And then that's when I got the original $240. My first reaction was, why is there a charge? Usually with grievances, for any kind of gathering of information, there isn't a charge for that. And prime example is when, well, the latest example is when we had the long investigation of the threatening of an employee or the Dawn Sheets case. The township actually pulled the instant chats, emails, and all of that. So with that being said, the township did not pay any fees or anything for the IT supervisor to gather all that information. And if you guys know, that was a very drawn out and long investigation. So that's where I was shocked about that. And then the amount of copies. So the FOIA request was from October 1st through the 18th. So my second look on it was approximately 516 pages. So at this point, from October 1st through the 18th, if the request was any communication about the temporary workers from that time from Clerk Rowe, Township Supervisor, and Human Resources. So what's that, 18, 19 days, right? 516 pages kind of seemed to me very excessive. So at this point, I'm saying 516 pages between all of them going back and forth like that, at this point, that's a conference. That's something that should have been set up to be spoken face to face. And I felt like I was being retaliated against with the charges because of my filing of the grievance. And I felt like I was being gouged as if it was Labor Day weekend, gas prices going up. So then I asked for a breakdown of the charges, and I was given another estimate of $170, and it took off Travis, the IT person's information. Originally, Clerk Rose said that it was going to be that he spent 45 minutes. So on the next revised one, it said that he only really took 10 minutes. So then that led me to believe if I would have paid the $240, I would have overpaid, right? Because his was really only 10 minutes. So the price was reduced to $172, and it said that, please know, all labor for Travis, Karen, Wallen, and Brenda has been completed. These are not estimated costs. So my other argument was the Michigan Freedom of Information Act states that the public body shall not charge more than the hourly rate of its lowest paid employee, capable of searching for, locating, and examining the public records in the particular instance, regardless of whether is available or who actually performs the labor. So if you notice on the charges with what I submitted, we have Madam Supervisor Clerk Rowe and Travis, the IT supervisor. My first argument is, and then human resources. So the one that says that this is not an estimate, the 172, Madam Supervisor and Karen Rowe, I argue that they are not employees. They are elected officials. So therefore, their charge should be removed if there is going to be a vote to be a charge. And I provided the information that supports my argument. And it just pretty much states that as used, 15.401, it says, as used in this act, public employees mean an employees of the state, classified civil services, or an employee of a political subdivision of the state who is not an elected official. So that's my other argument. And it appeared that the fringe benefits were included. And maybe Clerk Rowe can help me on that, because I feel like if there is going to be a charge, if there's never, I've done FOIAs before when I worked in the treasurer's office, and we were never charged, we never charged, or the clerk's office never charged any fringe benefits that was included in that. So, but it also states on the Michigan Freedom of Information Act that if you are going to charge that, it has to be clearly notified. So that wasn't on here also. So with the charge of the fringe benefits being included, it's just inconsistent to me. So because Clerk Rowe would have a family of 4 on as far as medical, and that includes your benefits, so then I am charged with that, versus if someone else was to request information and just say was one of the clerks, employee clerical staff, and then the fee would be a little different. My argument also is that Clerk Rowe was part of the grievance, and therefore I believe that's a conflict of interest. She should not have been gathering the information so that the information can be used as being honest, and that way it won't be any judgment. Therefore, I believe that a third party, which is our IT person, Travis, should have gathered the information. It says that between Karen Wallen was 300 pages, has been estimated. Madam Supervisor was 16 copies. And then Clerk Rowe, it says, based on the time it took Karen Wallen and Brenda to search their emails, 45 minutes has been estimated for her. So I just feel like that's excessive. I was 500 pages from that time. So I am looking to still receive the FOIA, because in order to have the support, the backup support for our grievance, I think that I need that information. And also, I believe that there needs to be a check and balance system. I encourage the board to maybe look into that with the clerk's office, because the township clerk is over the clerk's office, the election payroll, and the accounting department in which I work. And the reason why the FOIA is so important is because Clerk Rowe submits payroll for her family that will work the election with no hours, no hourly work, no hourly rate, where they worked. So in order for the union to properly identify that no non-union worker or person is doing ask me work, that needs to be clarified. So I'm recommending to the board that you look into the checks and balances, because that is what we receive. It just says pay Heather Rowe $200, pay Hannah Rowe $100, pay Rick Rowe $500, pay Sarah $300, and there's no backup. And that is what we receive. So just as a union member, there is no way to say, when did they work? Was it before hours? Was it after hours? Was the union notified or offered? So I do believe that there is an abuse of power, I feel, by Clerk Rowe. I feel that Clerk Rowe feels that she is above the rules and regulations. And I say that because that's why the grievance was filed, because this has happened, this has continued to happen, and that's why the grievance was filed. So you may say, okay, well, with the other ones that you were speaking of, one was a Saturday, one was a Sunday. When I filed the grievance, I believe 2 weeks before that, it was another violation. And, well, why didn't you say anything then? Well, at that particular time, the statute had expired, and according to our contract, you have to bring the information to HR within, I think it's 7 days, and I think, so each time had expired. But with all due fairness, I knew that it would happen again, and it did, and that's when I filed the grievance.
Mila, may I ask, what relief are you looking for? So you're appealing a certain amount?
I am actually asking the board to waive the fee. This is part of a grievance process, and part of a grievance process that was settled in favor of the union. And my argument would be there has never, ever been any charges that was that with the grievance, any FOIA or anything that supported the grievance, any investigation that was ever a charge. So that is what I'm looking for. If, for some reason, that the board decides to do the charge, I feel that it needs to be reviewed very closely, because I believe 500 sheets, and I will be looking for my actually 516 sheets. I did still receive an email as of yesterday, which still is mind-blowing, because I submitted the agenda item already, and I'm still getting emails, and the board was copied on it, saying, well, here is another total. I think it was $121 now. You know, we'll just put the copies on the USB drive. Well, so that the board is clear, I did ask for the USB drive in the beginning with the $240, and I was told that that would be an additional $5 on top of the $240. So that is just where I stand. I feel that there's a lot going on with this, and so to have it for the backup for my closing of my grievance for our union, that's for, not just for me, but just for historical reasons, so that anybody coming in after us, we can show that we have the paperwork that said that Clerk Rowe has violated the contract before, and with the history before and current, at that time current, and that the union was found to be correct and challenging that.
Madam Chair, I have a question. A couple of
Trustee
questions,
Meyer.
actually, if it's okay. Yeah, because I'm looking over the memos, it's two. The first one from October 24th, it does mention that it's $240.32, and it has the reasons why. The second one, which is from November 2nd, mentioned is $172.70, and it has the reasons why. I guess this is my question. Is it normal that we charge for FOIAs, for union grievances that were found in the favor of the union? That's my question. Or do we charge for FOIAs for union grievances, period? Or do we charge for unions to get FOIAs? I don't know. So that's the question I want to pose.
Are you finished, you want me to speak now?
Oh, I
Well,
just,
she asked a question on the,
Yeah. Just, I handed out to everybody a sheet because under the FOI procedures and guidelines, which you guys all have a copy of, it's like this, stapled. It's very specific about the appeal process and when it can be appealed and when it can be waived. And it says that, you know, if you are going to waive charges, that you have to have specific reasons, which that's all in there. And so I wanted to make sure that you had a copy of it. And we adopted that in, it actually went into effect in July of 2015. So part of the process was when we went through that, because Mila had not been specific according to the appeal, so then I had asked her, and so she presented her memo. And so really, I think that's what's in front of the board right now. There's been a lot of other stuff added, but right now it's whether or not we're going to do something with Mila's appeal for excessive charges for her FOI request related to grievance. So she had her first point was that she said that there was no knowledge, she had no knowledge of FOI requests in being involved. I had no knowledge of the opposite, that we'd ever given materials out without charging folks. So what I did was actually go back and do a search. I only went back to when we adopted this procedure, but we actually have a lot more. We could go farther. So what I found in there, which I have under reason number 1, in in support for Mila's charges that it's excessive in regards to that, I found only one request from an employee, and that was Dawn Scheitz, and she was requested to put a $1,000 deposit in for a $2,000 request. Hers recovered as for 17 or 16 months of emails that went for one particular employee. She never put up her deposit, and so that was kind of the end of that. I did research, because 2015 had January to July, so in there was also 2 or 3 specific requests for FOIAs from Larry James, and he was given information, because I think he was going through grievances and through discipline and stuff too, and he was giving information for what his charges would be, and that was before we adopted. So I'm sure if I went back farther, I'd find other chances where information was requested out of the clerk's office even before I was there where there was charges. So I have no knowledge of the clerk's department ever waiving fees for any grievance-related requests. I do know that some requests, or talking to others, is that some requests actually are part of negotiations. And so I know the attorneys and HR work that out, but my office I'm not involved in that. No one's come to me and said, hey, get all these information together and we're not charging them. So I have no knowledge of that ever happened in the past.
can I just make a comment
On
just on
reason
that?
2, when I get finished.
Okay.
According to the Michigan Freedom of Information Act, that the public body shall not charge more than the hourly wage, and she quotes Section 4A, and says that we're not supposed to do fringes. If you look at the policy, it says you do fringes, and we have, since that policy is adopted, we do fringes on every single one of our FOIAs. We include those. And she didn't mention that Section 4.2 says that it goes on beyond the section that she quoted, says that you can, it basically says when calculating labor costs under Sections 1A, which she references, B or E, the fee component shall be itemized in a manner that expresses both the hourly wage and the number of hours charged, and the public body can add up to 50% to the labor charge to cover or partially cover the cost of the fringe benefits. And Section 5 of our policy that this board adopted in July of 15 says that, not this board, but the board that was in place, says that the fee component shall be itemized in a outlines the calculation of the fees per the Michigan FOI statute. The fees include the labor cost hourly wage of 50% of fringes. That's how, since I've been clerk, that we've handled FOIAs, all of them. reason number 3 that she gives is that she quotes an act that actually refers, it's kind of taken out of the Hatch Act, which doesn't allow federal employees to be engaged in political activities. And then the state of Michigan adopted a similar public act that says that public employees, and it goes on to talk about civil service employees, and that if you were state of Michigan civil service employee, it gives the definition of what that is, and it doesn't include elected officials, and that, and so her argument is that that definition under that act, which is not the FOIA Act, should apply in this case. My first reaction was that that wasn't the case, because basically most all FOIAs, it just wouldn't make sense, because almost all of them involve communications with elected officials. Not all of them, but a lot. And that would mean that none of those would be covered. So I did engage with attorney Angela King, who kind of is the one, if you remember, worked on developing the policy and procedures and guidelines, and she's the one that we always refer to if there's any questions on our FOIA policy or procedures if we're not following. And she said that I was correct in that, and that that definition does not cover that, and that elected officials' communications, whether it's emails or letters or memos, are included in the public act that covers FOIAs. So that's not a list.
Clerk Rowe, did Mila get a copy of this?
Nope. No, I just finished that today, yeah.
Oh, okay.
Yeah. And then on the reason number 4 is that she indicated on the excessive number of copies, she indicated that she wanted to pick those up. So whenever people put that on their form, it's actually on the form, pick up documents. Her statement about that USB, that statement was never given by me. I've never ever heard that before. I don't know who specifically.
It was Janice.
Janice.
So she was handling the grievance, the FOIA
right.
before
So
her accident.
I didn't know anything about the request for the USB. So, and then of course, as you know, she had an accident and hasn't been here. But anyways, so I know that when Lisa put together the numbers on that, we were doing that based on and what folks really need to understand is that even the numbers that we've given recently, they're just estimates. And what happens is that when it's finally done, there's a sheet that goes together, a worksheet that actually has exactly how much each employee is paid, that goes through once we actually know. None of the work other than Travis did do the parameters, and he sent the emails to Karen Wallen. My understanding is Karen Wallen briefly looked at those, and so that's when the numbers changed, when she said she looked at them, so we kind of know more of what we're talking about. But it's only an estimate, and if the estimate comes out either lower or higher, or the actual cost comes up lower or higher, then that's actually, and if it's more, then we have to pay them back, or if it's not enough, then they have to pay more before we actually turn over the documents. That's the case on all of them. I know she talks about duplicates. No one's ran those copies, so we don't even know if there's duplicates in there. And the bottom line is that Karen Wallen will have to, because she was the one that Travis sent things to, so I'm not really even involved in that, but she'll have to she'll have to open each email, and she'll have to look at those and decide, and copy all those, and we don't even know.
Karen Wallen?
Yeah, because that's the way that Travis has it set up, that whenever he does a search, that he says the policy is that he's not allowed to give any information to any other employee it goes through human resources when it involves other employees. That's what he had said, and I don't know if that's what happened with the chat room stuff or whatever, but that's, and so there had to be a clearinghouse. We didn't need Brenda to go through and clear hers, or me to go through.
Well, I did clear mine, though, with Karen Wallen.
Right, that's what we were going to share them through Karen. So that estimate, we don't know, and even in talking to Travis, there's no emails were pulled from Karen to Brenda, which is part of what the request, so the numbers are even going to be different than what we have. So the bottom line is, until you actually pull everything, you really don't know what the time involved is or the cost. So everything is an estimate. And in trying, to be fair, because I knew that Mila had issues with the cost, I did ask Lisa when we found out that Travis had done his work, because we didn't know how long it was going to take him to pull 14 days or whatever it was of 500 and some emails that went back and forth, or whatever it was between Brenda and Karen and me and Brenda, and
They were the same.
it was 6 people. But no, you can't know that until you actually, till they actually pulled those all out. So, but once Travis had done the parameters and he sent it, so, because we didn't know before, he just gave us an estimate and he told us how much time he spent. So then we were able to adjust his hours. Karen Wan had looked at him briefly and she said, I think that'll be this much, and it'll probably be at least 200 pages and maybe 300, so we adjusted those. When Milas expressed for the first time that either Lisa or I knew that she would take it on a USB, then we saw that what probably can happen, we're really not sure, because it'll involve the time that it takes, because they have to be printed in order to be scanned back in, and then to be put on the electronic device. And so our assumption is that labor cost will be less than the 10 cents a copy, and so it will be less. But until we actually go through that we really don't know. But we do think, it's just a chance that you take when you say you want it on a USB. It could cost more than the 300. We don't think it's 500 now. It's probably closer to 300 sheets of paper, and they can be copied. We can do those, probably can copy those on back to back because they have to be printed anyways. And so when we scanned them, to put on the USB or to reprint them for you, then we could, for Mila, then we could put them back to back, which would reduce those costs. But like I said, the bottom line is it's only an estimate, and that until we actually do that. And I'm sorry, Mila, that you feel that it's retaliation, but I wasn't even really involved in all this. It kind of goes to Janice and then to Lisa, and all the numbers are put together and stuff, other than working with Travis and talking to him about the parameters. We had conversations with him about that. And so you're being treated exactly the same as every other person who puts in for a FOIA request. You can look at those files. Anybody can look at those and see that that's the way it's always put together. And I know I think people are surprised at how much it actually costs. The appeal is before the board. The policy and procedure says that you do have the right to make adjustments, but you actually have to say, why it is that the board needs to say why they want to make those adjustments. I did talk to Angela King again yesterday just to make sure that we're following the process appropriately. And that's when she reminded me, she says, Karen, it's totally a board decision. It's not anything, like I said, I'm really sorry that you feel that there's some retaliation about it, because it's a clear-cut policy and procedure that's established by the township board, and that's what we're following, and this board has the right to do what they want with that. My only thing would be whatever you decide, I think that that's how we should treat all FOI requests in the future for employees. Now, if you want to have a different set of rules or costs for employees, then the board can establish that, and you can do, if you can waive it, if that's
About
what.
grievances.
But I would be really concerned about, because we can't, like Dawn Scheitz's employee one, it would literally have taken people, hours, weeks of their time to do that and stuff. And the grievance says normally, my understanding is if it's something that the union is wanting or that they want it through negotiations or whatever, that is not handled by my office. That is not an FOIA request. That's handled through the attorneys, for both sides, for the union. And like I said.
So if she would have went to HR and not filed the FOIA, there would not be these charges maybe? Is that what?
I don't know. That's my understanding. I don't have anything in my files that shows where the union has requested something and we didn't, or where a person has requested something and we didn't charge, whether it was involving Don Scheitz's, which I have specific. That's the only one that I have back to July of 15. 2 more prior to that where Larry James asked for information related to his personal file and stuff. And both of those by my office was given charges just like Mila was given, saying, here's what it is. I was told, or it was shared, that perhaps that kind of information in the grievance process gets shared between the attorneys or the bargaining people or in a contract.
HR.
Yeah.
This is just a.
Right, but I don't have any knowledge of that. That's not, my office has never waived a fee. I don't have any authority under the policies and procedures to waive a fee for anybody, whether they're employee, whether, they're, a developer that comes in, or whether it's a resident, I have to follow policies and procedures that the board adopted, and that's what I do. But if you look under the appeal process, which is specifically in Mila's case, is for what she refers to as excessive charges. It's not denial of public record. It's on next to the last page of the stapled handout. It says specifically in there that if they feel that they're charged too much, it exceeds the amount, under the state law or the policy, she has to appeal to the board by writing that, and has to do that specifically, which she has done. She's outlined her specific charges on her memo dated November 29th, and that the board we're considered to receive that at our meeting. So tonight's the first night. We have 10 days to act on the appeal if we want, and that we can do the following, and you can see that on there, and we have to do it in writing. So I would suggest that at the board meeting tonight, that we need to have a motion on what it is that you want to do, so that I can send that in writing before the 10 days are up, because, before the next board meeting, it'd be too late. You can reduce the fee and issue a written determination saying why you are reducing that supports the remaining fee. You can uphold the fee and issue a written determination indicating the specific basis that supports the fee. And you can issue a notice telling the reasons for extent. Well, that's if you wanted to go more than 10 days, but I would highly recommend let's don't do that. Let's settle it. And where you reduce or uphold the fee, the determination must include a certification from the township board that the statements in the determination are accurate and that the reduced fee amount complies with its public available with these procedures. So in essence, you have to say what in these procedures was not upheld, that there's something wrong with the procedures.
Well, I believe also that you failed to mention that it says the lowest paid employee that's capable of doing the work. So that would be the lowest paid in your department, which is not you. You also stated that you weren't involved in the whole process, but yet you are still charging at the bottom for so many.
No, I meant in the looking up the information and giving you your saying, here's what your fee is. Someone has to go through those emails. And I would suspect at this point, Mila, if it goes forward and you, that Karen Wallen is going to get all those emails, as she has some of them, but we still got to get another session, whole big section of all the emails between her and Brenda that Travis didn't send. And she's going to go through those and send you or make copies of all the emails that are specific to what it was that you were requesting. Because
I'm not sure if the board knows that the IT person can just do a data drop.
That's what he's done.
Okay, well then.
I knew it.
But the 300 copies, so at that point though, so I'm interested in the copies, right? So if you're saying 500 is an estimate, and now you're saying it's 300 or whatever. So either way, however the board decides, I do have an issue with the grievances that you stated or you referenced. So then why is it then on the flip side is where the employee gets to charge, they go to you for the FOIA, you charge, but then in any other grievance situations, including the dawn sheets or the other employees, then when the township does their discovery, then there is no fee. So going back to the lowest employee, though.
Are you referencing like if Karen Wallen is researching a discipline or something that she should be charged?
No, I'm saying if the township is going to gather information, and we're just speaking of a grievance process, because this is how this was prompted, then there was no charge for the township. So then if the union requests any information, then there should be no charge to the employee. Also, the reason why there was no attorneys involved at that particular time, because we were not at that step. We were at the step 2 and 3, where I requested the FOIA so that I can have the information to decide if I was going to go forward. As far as the lowest paid employee in your department, it wouldn't be you, right? It would be either Janice, the lowest paid person. The fee should be with the supervisor's office would be Debbie Graham. The lowest person that I should be charged for in HR would be Robin Castle.
At this point,
So-
if I could just
so-
interrupt you. is
Actually,
that-
no. So my point is, if the board decides that there is a fee, it still needs to be adjusted because it was calculated incorrectly from the beginning. So going off of that information, and then to, what I also want to know is how 300 pages, if there isn't any duplicates from 18 days from one email to another, you're saying approximately now is 300 pages. So how did you come up with that? If you
It came
said,
from Karen Wallen. She estimates for sure 200, maybe 300. And just to make it clear, those numbers were in there, but we've since, discovered, okay, he did a data dump, and if you
so you're
follow-
saying Karen Wallen said it's 300 and something pages that she did alone, or just
200
everybody? Because it says.
He did a data dump and sent those to her with everything except for the part that you requested, the communications between her and Brenda. We think they're probably the same, but we don't know. So I don't need to go through, I'm not going through so my charge is probably when we get finished with it, I'm not planning on going through mine because we had decided on the data dump, and that Karen, that she can do it that way.
Right, so then
I mean,
where
at
you
this
get the
point,
copies?
another way maybe to solve it is if the board wants us to, is we could actually do it, and then you can know what it actually costs, and you can just pay to get what it actually costs, because right now, it is just an estimate, and I think the latest numbers is $60 for you to get all the information, and if we find out that it's less, than the $120, then you'll be charged less than that. If it's more than that, then you'll be charged more than that, because we don't know. Everything is just an estimate, because we haven't done it. The duplications and all.
I know, I do have a clarification. So you dumped the information,
Travis.
so then why is my cost your cost and Karen Wallen's?
Because before he dumped it, what I always ask departments to do is just give the estimate and not do the work. That's what I ask. But a lot of times people go at, no, I always ask that. There's some big red letters when it goes out to the department. Please give us an estimate. You don't have to do the work yet. But it's a really hard habit to break, and I'd say we're getting better. It's probably now about 80% of the departments are doing it, and 20% are still going through and getting information, which is what happened in this case. Travis went ahead and did the work. He did the data dump. He sent it to Karen. Karen Wallen spent time reviewing.
I did the work.
Brenda did the work on it, even though that's just an estimate. So some of it, we've got some actual real numbers and some we don't. The bottom line is we won't know the real cost until we do it.
I'll let Trustee Ross Williams, because I have one comment, but go ahead.
Thank you, Madam Chair. You brought up another point, and I wanted to kind of get clarity on that one. You had mentioned, basically, when you originally included this to be included, all of it, it was 12 pages, but then you went back and you looked and you found that it was 10.
It was 10, only 10,
Okay.
yes.
And that the only reason that you knew it was 10 was because you went and looked, and you didn't
No
know
one
anything
notified me.
about why those two were deleted. So I guess another question that I have, just a general question, is that also standard? I know things can be taken in and put out of packets, but if they are, should the person be notified that they're not going to be included inside of a packet?
On this particular case, which is kind of where we rambled all over tonight too, it was specifically about the FOIA, and I was trying to keep the packet to that. But when when Mila came to see Lisa and objected, said, well, if it's a big deal to her, then we'll go ahead and put it in there because it really has no bearing on what we're voting on tonight.
Well, just so the board know, without the
Right.
grievance, there wouldn't be a FOIA. So I'm trying to figure out how those aren't connected. So, and I'm also questioning if it took Madam Supervisor's 15 minutes to do, or 16 minutes to do hers. And if it was just copies of the people that were involved were just copied on the emails, then why is hers 16 minutes and it took everyone else's hour and 45 minutes or more? So that's what I'm just trying to figure out, that it's hard for me to believe that Human Resources would not copy Madam Supervisor on any kind of communication with Clerk Rowe, especially since Madam Supervisor is over the supervisor's office. So that's what really, it took her 16 minutes, Madam Supervisor, and then everyone else, it was an hour and 45. So I'm just trying to figure out that doesn't really make sense to me. So like I said, I just feel like that with it being part of the grievance process, that is my request for it to be waived. You said it's a bad habit to break in regards to we pretty much state a fee and ask questions later. That is not something that I would be proud of in the clerk's office, because then when someone off this, like a resident would come in and request that information, then even though it says an estimate, you're saying an estimate, the 516 pages for 18 days, that's just high to me. So like I said, I'm definitely interested in the copies. I'm no longer interested in the USB drive, for it to be placed on a USB drive. And I'm sorry.
I was just to try to move it along, and I thank you for coming forward with the information. Do trustees have other questions on it before the board meeting?
I apologize. I had to excuse myself to go to the bathroom. So I just wanted to understand. So I feel like I still don't understand how much we're charging. Is that correct? Do I have that correct? So
We won't know what we're charging until it's completed.
Okay.
There's an estimate given based on the information that the different employees have provided.
So through that, like now it's just an estimate, but if I'm reading this section 9 in the appeal process, it says waiving the fee. Like it's talking about a defined fee, and we don't know that defined fee yet. So I'm just wondering if, like, doesn't the clerk's office need to figure out how much it costs before we can go through the appeal process?
Well, then maybe that should have been sent out before sending a bill with the deposit. Because if I would have paid the deposit fee, Trustee Rowe, and then based on the estimate that she gave, then that would have been based off of the 516 pages.
So, let me clarify, Myla. So your appeal is about your deposit fee at the moment?
No,
or
it's about the
total fee?
entire
Okay,
fee.
because I want to make sure I'm up to
So
speed
it's
with the
more
whole
than
board.
just
So I'm
one.
just,
Yep, it's
excuse
the
me, I'm
fee,
talking,
and then it's also
Myla, you're
the
talking
other-
over me. I'm trying to clarify.
So you asked the question, so.
My question is, so you're going over the whole fee, which we still don't know to this point.
But she just wants it waived. That's what she's asked.
But how can we waive something when the process is about waiving the fee and we don't know how much the fee is? Like, how do we not know how much the fee is going to be yet? Like what, a FOIA request usually has a time frame around it too.
So am I talking?
Can I speak just real quick? In the policies,
Lisa?
I'm sorry, Lisa Stanfield. In the policies and procedures that was approved by the board in 2015 in section 3, it does state that if the cost of processing a FOIA request is $50 or less, the requester will be notified of the amount due and where the documents can be obtained. I'm sorry, the next sentence. If the cost of the processing of a FOIA is expected to exceed $50 based on a good faith calculation, or if the requester has not paid in full for a previously granted request, the township will require a good faith deposit pursuant to section 4 of this policy before processing the request. So it is in our policies and procedures that we don't fulfill these requests and process them until we've received a good faith deposit.
But with all due respect, I wasn't questioning the deposit.
I understand what you're saying.
I was just saying.
Well, Heather was kind of asking.
Well,
why we
and
hadn't
this
done
is
it
our
before,
first
so
appeal.
I was just making sure.
I just, for the record, we've never
Had an appeal.
had this in,
I understand.
Ma'am,
yeah,
Sorry.
Stan.
I used to have a quick question, then I apologize, I have to get up and go to the restroom. No. The deposits, when they're made, let's just, for instance, I make a request, and I'm a citizen, I come in and make a request, and the estimate is $100. I'm required then to pay $50, if I'm hearing correct. If the estimate then comes back and the real cost exceeds $500, I go, oh, wait a minute, that's a lot more than I thought I would be charged. I don't want it now. Am I reimbursed the 50 or is that 50 gone?
No, it's gone.
So my question is, how can a person then make a deposit of 50% of something they don't know what the real cost will be?
They're making it of the good faith estimate, as Lisa just read from the policy.
And if I'm hearing correct, though, that sounds like where the breakdown is right now is, it seems to be a question of, is there good faith or not? And I have a lot of questions about it. One is, if in fact it is the lowest paid person in a department that should be compiling these, based on what I've got on my computer and on hard copies here, it doesn't look like we did that. So, I mean, I have a number of concerns.
I just want to speak to the lowest person in the department. I mean, Mila's request was for emails from Karen Lovejoy Rowe, Karen Wallen, Brenda Stumbo, between them,
There's
like
six
six different
different.
ways, yeah. And I'm pretty sure that Supervisor Stumbo would not want Debbie Graham to go through all of her emails to,
For that data dump.
yeah, to look for and read every, because when you do that data dump, it's gonna pull every email that Brenda has received or sent. And there's information in those emails that I'm sure she doesn't want a random person in her office reading and going through. So it has to be completed either in the data dump by Karen Wallen or by the actual people that Mila requested the emails from, because they're just not able to have, Janice can't just sit at Karen's desk and go through her emails. It's not appropriate.
Okay.
That would be,
HIPAA
that's my,
violations
and that's my position,
Debbie
you know.
could have done it for me.
Yeah.
Well, I guess
just to answer,
I guess
yeah.
my question would be, I certainly don't disagree that maybe none of us would want emails read, but what does the law say? I guess that's where I would hearken back to. If it doesn't specify that, geez, I am in a certain position within an organization or municipality and I don't want one of my subordinates reading my emails, does the law speak to that, or does it say?
It says the person in the department of the lowest pay who can perform the duty. So no one else in our department could perform the duty of going through Karen, the clerk's emails.
But in the
same as-
past, if I could clarify, because I did it for 16 years, we did not charge for, the healthcare benefits and everything. That policy came afterwards.
yeah, I can't
No,
speak to
no,
that because that's
I'm
just
not
part of that new
asking you
policy.
to, But
Yeah.
you still can charge with the lowest person. Even though I performed it, you could still charge the rate per hour of the lowest person.
If I could
Yeah,
just intervene
that's
one
not
more
how I
thing.
understand it.
That's how we did it.
Yeah. Well, I don't believe that's how the policy is currently set up, so. Excuse me, sorry.
And the last thing I would speak to is Karen may recall, many years ago when I was a new trustee, I had requested information on a certain topic through Karen with our labor attorney, and I was initially told that I couldn't have it unless I paid a FOIA, and I said, you're kidding me, I'm no different than an employee, whether I'm an elected official or not. You're telling me I have to pay for information even though I'm a part of this township. And within 24 hours, those fees were waived, and I was given that information in full.
And just to clarify with Lisa's comment, Debbie Graham, if they would have asked, that Debbie Graham has access to all of Brenda Stumbo's, Madam Supervisor's emails, and also with Karen Wallen, Robin Castle, who is also part of HR, she would be considered the lowest paid because she is also Human Resources and is privy to that information. So I'm just, and then, let's see, who is that? And then as far as with the clerk's office, it's whoever, it doesn't matter who gathered the information, is who is the lowest paid. So I think that that's where the breakdown to, no matter who does the work, it says whoever who actually performs the labor, it is the lowest paid employee capable.
Madam Chair.
So.
Thanks, Monica. I'm sorry,
Yeah.
I'm going back to this fee thing. So
have
going
2
off
minutes.
of Stan's question, he said if, his required deposit fee was like $50, and then let's say the FOIA request turned out to cost $45, what happens to that other $5?
Well, if it was 45, then they didn't have to make a deposit. Because anything under 50.
If it was $100 and I made a deposit of 50 and I'm just saying so the reason I'm asking is
Make the
because if Lila
adjustment.
made her deposit of $86, but you're not anticipating, if the total fee came back to be $100.
She would get her money back. Or she'd only
Like,
have,
it would
she
just
would
be fine, right?
It would
And
be
you
the
But that's
whole
not the
$100.
that you're,
Right.
and I understand why you want the document. So at a deposit fee of $86, assuming that it's gonna only be less, like the fee's only gonna continue to get less. I just don't, I'm still struggling, like if you'd pay the $86 no matter what. Let's say the fee comes back tomorrow and it's $100, like maybe that's reasonable. Or maybe it comes back tomorrow and it's $200. You still want those things, and so the deposit, like, that's why I don't understand why we're at the process right now instead of doing it once you're totally
Well, here's the
charged.
thing, I'm not sure if you were in the restroom, but Clerk Rowe stated that with the deposit, that you lose it. So I'm not sure now
You
you're
would be
saying.
getting the fee.
No, what I said was, is if you said you made your deposit, and then we did all the work, and it was more than you wanted to pay, and you said, no, forget it, I don't want it, you don't get your deposit back, because we took that money
Okay,
for
here's
you.
a
It also goes farther, if you did that in the policy, you wouldn't be able, you'd have to pay even, not the total estimate up front, not just 50%. It's in the policy.
So to answer your question, Trustee Rowe, I wanted the information, no matter what, as long as it's calculated correctly. So here's a question. So Madam Supervisor was also was one of the information, the persons that gathered information. So if at some point, then we're speaking on if you said you did the work and you don't want it. So if you gather the information and then I'm like, okay, well, one, would I to have the option to just look at it? And then if I just wanted Supervisor Stumbles' information, is that possible?
If you wanted to view it in person, yeah, you can.
Those are two questions, I'm sorry. So
You can
one,
view it in person. There's, and that calculation for those charges is different. So of course, you don't get the copy charges.
okay, and then
What was your other
the
question?
second question is, of the 3 people that are listed on here, 3 or 4, or however many it was, so then can I just say, okay, well, if the charge come back, let's just say is $1,500, and I say, you know what, Supervisor Rose was only $30, I'll just take her portion.
You can always, if you wanted, if we haven't done you can always change it, and people do that. A lot of times people send one in saying, I want everything on a certain address, and so, they'll say, well, that's going to cost you a lot, and then they'll say, oh, well, I'm really looking for these 3 months.
So that is possible.
So it is possible for you at this point, because the work, even though some work has been completed, even though people weren't supposed to, you don't have to pay the penalty for that, that you can change your FOIA requests and say, I only want the emails from Karen Wallen to Brenda Stumbo, or from Karen Wallen to me, or
And
from me to Brenda, whatever.
And just to clarify on your statement, the reason why that I did bring it is because it said that these costs are, please note all labor, travel, so, and yes, and it says that these are not estimated costs. So that's why I was like, okay, well, fine, we'll just go. Okay, all
Madam
right.
Chair, just have.
Yes.
Just want to.
You have to take a break for the.
Yeah, and I'll make the comment very quick. Here's my question. I guess this policy was done in it was done in 2015. I hadn't known this policy exists. I don't know if other trustees that are new that it exists. And so I can just speak for myself. There was 2 different cases that you brought up. You brought up a previous employee that's no longer with Township, in this case. And so in that case, that if I have it correct, that was not filed for the employee, blah, blah, blah. But in the same aspect, I don't know if we should be charging for grievances for FOIAs if it was found in favor of the union. That's the question I have. And so with that, that is also my comment. And I'll, I guess discuss that more in general session.
Thank you so much for your time.
Thank you. All right, we're going to adjourn the work session, and we'll be back here in 5 minutes, 6:55.
And then can we take the Huron River Shed people first on the agenda? Yeah. We come and tell them at 6 o'clock. Yeah. 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 Oh, thank you.